Yes. Mr. Ainsworth and his company were liable under United States law for infringing the claimant's United States copyrights in the United States. That is no longer disputed. The main issues before Mr. Justice Mann were essentially these, and any short summary of the issues before Mr. Justice Mann would be bound to seem to some extent by omission, because there were a large number of them. But they were, first of all, whether Mr. Ainsworth had copied the material supplied to him, or was, as he claimed, the real designer of the stormtrooper figures. The second major area of dispute was who owned whatever copyright subsisted in the helmets and armour, Mr. Ainsworth contending that he did, and that he had not impliedly undertaken to assign back the copyright to the people who had commissioned his work. He failed on both of those points, and neither issue is part of this appeal. The judge held that he was not the real designer and didn't own whatever copyright subsisted. As far as the United States copyrights themselves were concerned, the only issue was whether the objects were functional, it being common ground that functional objects were not protected by US copyrights any more than they were in English law. Now, there is a suggestion in the respondent's printed case that the limited scope of the challenge on US law was only because the respondents could not afford to call expert evidence. The court need not take that point too seriously. The respondents did serve an expert report on US law at the trial, but as the judge records in his judgment, the report didn't take issue with any of the main points in the report of Professor Mennel, who was my client's expert. In any event, they did not, in the event, call their expert. Ultimately, the only defence to our claim on the US copyrights was that although by the end of the trial there was pretty well no substantive issue between the parties, relief in respect of it was beyond the subject matter jurisdiction of the English courts. And that was the submission that the Court of Appeal accepted. Now, the result has been to create what we have described in our printed case as a jurisdictional black hole. The only courts with subject matter jurisdiction have no personal jurisdiction, because Mr. Ainsworth is domiciled here and has been careful not to enter an unconditional appearance in the United States.
They have no personal jurisdiction from the point of view of English law?
From the point of view of English law, yes. And the only courts with personal jurisdiction, which are those of England, have no subject matter jurisdiction according to the Court of Appeal. Now, the Court of Appeal reached this conclusion by analogy with the rule relating to title to foreign land as it existed at common law before it was modified by statute in 1982. And they held that the rule applied in its most extreme, unmodified form to every species of intellectual property right. This was a conclusion that they fortified by a number of pragmatic considerations which led them to say that it was unsatisfactory to allow people to sue on foreign intellectual property rights in the absence of some reciprocal international agreement incorporated into English law. Now, in our submission, this is wrong in principle at every stage of the analysis. And I shall be making 4 submissions, which are not always easily separated, but all the material I shall be referring the court to goes to one or other of them. The first is that the common law rule is an anomalous rule relating to disputes about foreign immovable property, which is based on considerations of international comity. It cannot, in our submission, sensibly be extended to an action on an incorporeal property right, such as copyright, which arises out of the general law of a foreign country. Such a right is no different in kind from an action on foreign movable property, or indeed an action on a foreign debt, or in tort for breach of a foreign statutory duty. In other words, there's nothing special about copyright disputes that requires the English courts to apply anything other than their ordinary rule namely that if personal jurisdiction is established, the court may adjudicate on claims for any civil wrong, applying whichever may be the lex causae in accordance with ordinary principles of private international law. Secondly, in our submission, even in relation to immovable property, the rule is more limited today than it was when it was first formulated at the end of the 19th century in the Mozambique case. Its application, not just to intellectual property rights, but to questions of infringement, such as those arising in the present action, therefore go well beyond the modern ambit of the rule which the Court of Appeal was professing to apply. Thirdly, we respectfully reject the supposed pragmatic grounds on which the Court of Appeal founded part of their conclusions. Even if there was something inherently problematic, inconvenient or unsatisfactory about determining in England a claim on what is, for practical purposes, a foreign tort, it could not be, in our submission, a ground for saying that the English courts lacked jurisdiction. It could only, at best, be a reason for declining to exercise that jurisdiction on the ground of forum non conveniens. That, of course, is something that would never be open to a court in a case where there was no alternative forum, as is the position here. Fourthly, we submit that if, contrary to our submission, there is a common law rule of non-justiciability affecting foreign copyrights, then it has been displaced by the Brussels Convention and now the EU Judgments Regulation, notwithstanding that the United States, the origin of the copyrights in question, is not party to those instruments. Now, the first thing that I need to do is to take the court to the two leading cases on the common law rule as it applied to land, which is the starting point for the whole of the analysis of the Court of Appeal. Under the Judicature Act of 1873, or until, perhaps I should say, the Judicature Act of 1873, this was an issue that couldn't have arisen in England because the procedural rules about venue limited the territorial jurisdiction of local courts to land within their own area. Historically, the rules about venue had arisen because in the early days of civil juries, locally empanelled juries were regarded as witnesses and they could not be expected to know about land in another district. In the Compagnia de Mozambique case in 1893, the Court of Appeal had held by a majority that the abolition of the rules about venue by the Act of 1873 removed the previous constraints against deciding issues of trespass to foreign land. That view was rejected by Lord Esher in his dissenting judgment in the Court of Appeal, and Lord Esher's view was adopted by the House of Lords, which placed the rule on a much broader basis of principle, based essentially on considerations of international comity, and what they regarded at the time as being the universal practice of civilized nations as to the proper limits of national jurisdiction as a matter of private international law. Now, it's worth starting with the dissenting judgment of Lord Esher in the Court of Appeal. The report will be found in Volume 2 of the Authorities volumes at flag 12. And the relevant passage starts at page 395 of the report, which is at page 18 of the printout. And if one can start about just above halfway down the page on page 18 of the printout.
Having regard to the expenditure in this case on daily transcript, one might have thought it would have been possible to give us the proper law reports rather than these printouts.
I respectfully agree that is always preferable.
And also to bind them in rather more volumes so that those of us who don't have quite the muscle power of others in the room can actually lift them without paying.
Yes. Well, I'm sure my instructing solicitors will bear both points in mind in future cases. The first cardinal rule, Lord Esher says, this is about just above halfway down the page, agreed upon by all jurists, is one arising necessarily from the divisions of mankind into nations. It is plain that the laws of one country can have no intrinsic force proprio vigore, except within the territorial limits and jurisdictions of that country. Whatever extraterritorial force they are to have is the result not of any original power to extend them abroad, but of that respect which from motives of public policy other nations are disposed to yield to them. This is the natural principle flowing from the equality and independence of nations. The direct consequence of this rule, these are all quotations from Story, is that laws of every state affect and bind directly all property, whether real or personal, within its territory, and all persons who are resident within it, whether natural-born subjects of aliens, and also all contracts made and acts done within it. A state may therefore regulate the validity of contracts and other acts done within it, the resulting rights and duties, calling for the interposition of its tribunals to protect and vindicate and secure the wholesome agency of its own laws. Another maximal proposition is that no state or nation can by its laws directly affect or bind property out of its own territory or bind persons not resident therein. With regard then to acts done within the territory of a nation, all are agreed that such a nation has without more jurisdiction to determine the resulting rights growing out of those acts, but with regard to acts done outside its territory, no jurisdiction. This reduces the question under discussion to be whether in regard to an act of trespass done to land situated outside its territory, there is evidence to justify the inference that by the Comity of Nations, the jurisdiction to determine the rights resulting from such an act has been allowed by other nations to this country and has been accepted by this country. And the form of the inquiry shows that the solution to that question does not depend on the laws of procedure in litigation adopted by this country, but upon the Comity of Nations as between this country and other countries, in a long examination of cases in which, by a tacit universal consent of all civilized nations, it is to be inferred that each of them has recognized the jurisdiction of other nations in some matters extraterritorial. Story has shown that all nations have recognized a distinction between what civil lawyers or writers have called personal and real laws and between movable and immovable property. As to the former, it is to be noticed that they use the word statute as meaning law. The civilians have variously defined the different classes of laws, statutes or laws. Personal statutes are held by them to be of general obligation and force everywhere, but real statutes are held to have no extraterritorial force or obligation. And that is amplified by reference to citations from Merlin. And halfway down, page 19 of the printout, he cites these words, "But be the origin of the doctrine what it may, it has so general a sanction among all civilized nations that it may now be treated as part of the jus gentium. Lord Loughborough has stated it with great clearness and force in one of his most elaborate judgments. It is a clear proposition not only of the law of England, but of every country in the world where the law has the semblance of science, that personal property has no locality." And in due course, the court might find it convenient to read on further in Lord Esher's analysis. But that gives the court the essence of his reasoning. Now, if you turn back to flag 11, where the report of the House of Lords decision will be found, there were two recent speeches in the House of Lords by Lord Herschel and Lord Halsbury, both of whom derived the same principle as Lord Esher had done from Story and from Vattel's Droit des gens. Lord Herschel distinguished between matters which were, as he put it, transitory or personal, which could be tried by an English court whenever it had personal jurisdiction over the defendant, and matters which, in his words, were local in their nature, and therefore beyond the jurisdiction of a court sitting outside the relevant locality. And that was a distinction which he founded on international comity and the uniform practice of nations. That will be found in pages 622 to 624 of the report, which is at page 10, starts at page 11 of the printout. This distinction, he says at the top of the page, between matters which are transitory or personal and those which are local in their nature, and the refusal to exercise jurisdiction as regards the latter, where they occur outside the territorial limits, is not confined to the jurisprudence of this country. Story, in his work on conflicts, after stating that by Roman law a suit may in many cases be brought either where property was situated or where the party sued had his domicile, proceeds to say that even in countries acknowledging the Roman law, it has become a very general principle that suits in rem should be brought where the property is situated, and this principle is applied with almost universal approbation in regard to immovable property. The same rule applies to mixed actions. And he then cites the quotation in Story from Vattel and the doctrine laid down by foreign jurists, which is said by Story to coincide in many respects with that of our common law, obviously had relation to the question of jurisdiction and not to any technical rules. Then at the bottom of that page of the printout, by the words untenable according to the actual jurisprudence of England, I don't think that Story was referring to the rules which in this country regulated the place of trial in the case of local actions, nor am I satisfied that either Lord Mansfield or Story would have regarded an action of trespass to land as a suit for personal damages only if the title to the land were in issue, and in order to determine whether there was a right to damages, it was necessary for the court to adjudicate upon the conflicting claims of the parties to real estate. Over the page, the question what jurisdiction can be exercised by courts of any country according to its municipal law cannot, I think, be conclusively determined by reference to the principles of international law. No nation can execute its judgments, whether against persons or movables or real property in the country of another. On the other hand, if the courts of a country were to claim against a person resident there jurisdiction to adjudicate upon the title to land in a foreign country and to enforce its adjudication in personam, it is by no means certain that any rule of international law would be violated. But in considering what jurisdiction our courts possess and have claimed to possess in relation to matters arising out of the country, the principles which have found general acceptance among civilized nations as defining the limits of jurisdiction are of great weight. And then 2 paragraphs further down on that page, the learned lord refers to the practical inconveniences that might arise from such a course, namely the inability of a court to give direct effect to its judgments in a foreign country, particularly where they relate to title or possession of land. Now, Lord Halsbury made exactly the same observations, and I think it's sufficient for present purposes to take the second paragraph of his speech as it appears on page 15 of the printout. No 2 questions can be more distinct than the question whether a matter is in the jurisdiction of the English courts at all, and whether a matter undoubtedly within the jurisdiction of the courts shall be assigned for trial to particular courts in England. There is a concurrence of opinion of most jurists, if not all, as to the difference between what we call realty and personalty, by whatever words those things are distinguished in the jurisprudence of foreign countries, which affects very materially the right to try. And he then cites Vattel and Story, and then concludes, I think what Mr. Justice Story intended to refer to was the actual system of our common law at the time he wrote, and undoubtedly the current of authority at the time was all in one direction, although the original state of our law may not be very important in respect of the controversy now before your lordships. There is one view that it seems to me to throw considerable light on the question of controversy. Now, Lord Macnaghten and Lord Morris concurred. The rule was subsequently analysed on a very similar basis by Lord Wilberforce in Hesperides Hotels in the same bundle at flag 20. I'm not going to read extensively from Hesperides Hotels. I would, however, ask the court to turn it up for a particular purpose. In this case, the House of Lords was invited to depart from the Mozambique rule, either altogether or by limiting it to cases where the real dispute was about title to land rather than about damages for trespass to property where title was substantially undisputed. And Lord Wilberforce considered the rule and the suggestion as to how it might be limited at page 534 of the report, page 21 of the printout, where he sets out the rule in the form stated in the then current edition of Dicey and Morris, and in the form which he said still represented English law. That said, subject to the exceptions hereinafter mentioned, the court has no jurisdiction to entertain an action for 1, the determination of Title II, or the right to the possession of any immovable situated out of England, foreign land, or 2, the recovery of damages for trespass to such an immovable. As we shall see, the second limb of that formulation has since been modified by statute. He then, after that citation, says that the rule exists in 2 parts and concludes that both parts remain good law. He obviously recognised that the rule was open to criticism, but he regarded it as too well established to be changed by reference to the practice direction of 1966. And at page 536 of the report, bottom half of page 23 of the printout, he says, the rule being then as I have stated it, should your lordships accede to the appellant's invitation to restate it in different terms. There is no doubt that the rule can be criticised. Although Professor Dicey seems to have approved of it, the diligence of the appellant's counsel has assembled a massive volume of academic hostility to the rule as illogical and productive of injustice. Some of that is then cited. Although these writers are concerned with the conflict of laws as to which academic authority is of particular value, rather than with English law as to jurisdiction, which is what now concerns us, the consensus as to where considerations of logic and justice might lead if this matter were tabula rasa is impressive. But there are other factors to be weighed when revision of an old established rule sanctioned by this House is suggested. First, the rule is accepted with differing degrees of force and emphasis in other jurisdictions of the common law, and he refers to Potter and Broken Hill Proprietary, which we'll be coming to in a moment, and a number of other cases in the Commonwealth. In the United States of America, over the page, the rule appears to be accepted in the great majority of jurisdictions, Arkansas, Minnesota and Missouri being the only states in which has been judicially departed from. In general, the courts have followed the judgment of Marshall Circuit Justice, subsequently Chief Justice of the Supreme Court in Livingston and Jefferson, in which the learned judge, seeing no good reason for the rule, upheld it for the sake of consistency and continuity. In New York and Virginia, it has been altered by statute. In Scotland, a similar rule prevails without the certainty of definition. Secondly, the nature of the rule itself, involving, as it clearly must, possible conflict with foreign jurisdictions and possible entry into and involvement with political questions of some delicacy, does not favour revision, assuming such to be logically desirable by judicial decision, but rather by legislation. And he cites the judgment of the New York Court of Appeals in Brisbane and Pennsylvania Railway to that effect. Thirdly, revision of the rule may necessitate consequential changes in the law. In order to prevent forum shopping and overlapping, one such change would have to relate to forum non conveniens, a principle not yet fully developed in England, and if the English courts were to be given an extended jurisdiction requiring legislative definition. Fourthly, it cannot be said that since 1893 there has been such a change of circumstances as to justify this House in changing the rule. Now, we'll see that the second and third of those points have been overtaken by events in that statute has now intervened and forum non conveniens is now an established principle of English law. Moreover, I shall submit that the consensus referred to in the fourth point, or the first point rather, is not present any longer either. Now, Lord Fraser, at page 543 of the report, or page 27 of the printout, page 29 of the printout, also refers to the criticisms of the illogicality of the rule, which may leave a plaintiff without a remedy, and expresses himself from the bottom of page 29 of the printout to two-thirds of the way down page 30 in somewhat stronger terms, as to the unsatisfactory character of the rule, while nevertheless accepting that it is too well established to be departed from by judicial decision. Now, it's right to point out that even in relation to land, the rule has always been subject to common law exceptions, and these have added an element of arbitrariness to its application. The most important of the common law exceptions is that the Mozambique rule has never been applied to a case where, although the dispute may be about title, the cause of action is based on a personal obligation, for example, under a contract or in equity. Thus, if you have contracted to transfer an interest in a foreign property to the plaintiff, he may sue you for damages for breach of contract, but not for trespass if you are occupying the property. Personal obligations relating to land are therefore justiciable in any court with personal jurisdiction over the defendants, even if in order to decide the contractual or equitable claim, the court has to determine an issue of title. And if the court would take Bundle 6, which is a loose leaf additional file added to your papers this morning, with some additional material in it, and turn to flag 2, you'll see that under Rule 122 of this extract from Dicey, Morris and Collins, page 1142 of the work, that deals with jurisdiction of the English court in relation to foreign land, and sub-rule 3 over the page is subject to the judgments regulation, the 1968 Convention and the Lugano Convention. The court has no jurisdiction to entertain proceedings for determination of the title to or right to possession of immovable property situated outside England. That modifies the rule to reflect the Civil Jurisdiction and Judgments Act 1982, except where, and A, the claim is based on a contract or equity between the parties, and that exception is then discussed at paragraph 23041 on page 1150. I won't read this out, but I refer the court to where the discussion will be found. It's 23041, 23042, and continuing up to the end of that section on page 1154. Now, that exception was mentioned by Lord Esher in his dissenting judgment in Mozambique itself. He said that it was inconsistent with the principle that he had formulated in the case of trespass, and asked himself whether it was really right for the English court to do, as he put it, indirectly that which it dared not do directly. That observation is actually quoted in this passage from Dicey and Morris at page 1153, just below halfway down the page. There is, however, no doubt that the rule is well established. It was well established in 1893, and it has continued to be applied since then. Now, since the decision in Hesperides Hotels, the rule has retreated as a result of two legal developments. First, in cases governed by the Brussels or Lugano Conventions, or now the EU Judgments Regulation, these instruments assigned exclusive jurisdiction in disputes about land on a narrower basis. And that can be seen from Bundle 1 of the Authorities Bundle, flag 16, where you will find the Judgments Regulation, which in all relevant respects is identical both to the corresponding provisions of the Brussels Convention and to the provisions of the Lugano Convention. And if you turn to Article 22, which is the exclusive jurisdiction provision of the regulation, the corresponding article in the Brussels Convention was Article 16, that provides the following courts shall have exclusive jurisdiction regardless of domicile. 1, in proceedings which have as their object rights in rem in immovable property or tenancies of immovable property, the courts of the member state in which the property is situated. And while you have this open, may I ask you to note at paragraph 4, the provision in relation to intellectual property rights. In proceedings concerned with the registration or validity of patents, trademarks, designs, or other similar rights required to be deposited or registered, this is paragraph 4, or Article 22, the courts of the member state in which the deposit or registration has been applied for, has taken place, or is under the terms of a community instrument or an international convention deemed to have taken place. And I'll come back to the effect of that shortly. Now, therefore, in cases not within the exclusive jurisdiction of another member state under Article 22, jurisdiction is optionally assigned under Article 5 to the jurisdiction of the country where the harmful event occurred. And we'll see that in Article 5 earlier on in the extract copied. A person domiciled in a member state may in another member state be sued, and then it's 1.3 in the right-hand column, in matters relating to tort, delict or quasi-delict in the courts for the place where the harmful event occurred or may occur. But that is an optional basis of jurisdiction, evidently at the option of the plaintiff. The default rule is the one contained in Article 2. Subject to this regulation, persons domiciled in a member state shall, whatever their nationality, be sued in the courts of that member state. So unless exclusive jurisdiction applies, or the plaintiff has exercised his option to sue in the place where the harmful event occurred, in relation to cases in tort, or corresponding cases, the rule is jurisdiction of the defendant's domicile. Now, the European rule differs in two notable respects from the old common law rule as stated in Mozambique and Hesperides hotels. In the first place, the European rule is limited to disputes, and this is in the case of land, which, as the article puts it, have as their object rights in rem. In other words, cases within the first limb of the common law rule, as stated in Hesperides Hotel by reference to the then edition, current edition of Dicey and Morris. Cases, in other words, where the issue is the existence of title rather than infringement of an undisputed title. The European Court has held that the cases in which exclusive jurisdiction is conferred by what is now Article 22 of the regulation have got to be narrowly construed and should not be extended any further than is strictly required by their purpose. And the best place to collect that jurisprudence is in the summary in Dicey and Morris, which you will find in Bundle 4 of the Authorities Bundle, and I apologise for the fact that there are a number of extracts from Dicey, Morris and Collins which are sorry, I've got the reference wrong, forgive me.
The publishers and editors would have preferred you to have produced hard copies of the book.
They would, but that hasn't been the practice of this court for a very long time. There's 1136. Yes, sorry. Could you turn to flag 5 in Bundle 4? Clause 1 of the rule, this is on page 1136 of the extract, paragraph 23010. This is based on the first sentence of Article 22.1 of the Judgments Regulation, which replaced Article 16.1a of the Brussels Convention. The substance of the two provisions is identical. It provides that in proceedings which have as their object rights in rem, in, or tenancies of immovable property, the courts of the regulation state in which the property is situated have exclusive jurisdiction. The expression proceedings which have as their object rights in rem, in, or tenancies of immovable property does not fit with any previously existing concept of English property law in England, Its origin owes more to French law, and it has a well-established notion, of action réelle immobilier, actions involving title to immovables, but not actions of a contractual nature which involve title to land. Leases of immovables were specially included in Article 16.1 of the 1968 Convention, because in French law, a lease is a personal and not a real right. But what are immovables, or what actions have as their objects rights in rem or tenancies of immovable property, will not be a matter for national law, but must be determined by interpretation of a uniform concept. The European Court has held that Article 16 of the Convention must not be given a wider interpretation than was required by its objective. There are several questions with regard to the category of proceedings which have as their object rights in rem in immovable property. The expression is clearly aimed at proceedings involving title or possession, so a claim by a trustee in bankruptcy that he's entitled to a half share in a villa falls within Article 22.1 of the Judgments Regulation. Conversely, it doesn't include a claim for damage caused to an immovable, a claim for compensation for use of land during the period between its transfer to the defendant and the annulment of the transfer, and an action polienne under French law, i.e. proceedings to set aside a gift of immovable property made in fraud of the donor's creditors, or an action to enforce an obligation to restore a building, nor is it concerned, it seems, with a claim concerning the purely contractual aspects of a property transaction, such as an action for rescission of a contract for the sale of land, a claim for the payment of damages for failure to complete a purchase, or even a claim for specific performance. Thus, if two Englishmen agree on a sale of a house in France from one to the other, one could sue the other in England for failure to complete, or for an order requiring completion, but they would have to go to the French courts if an order for possession was required. There's then a reference to Webb and Webb, which I'm going to turn to in a moment. So the European Court has held that cases in which the exclusive jurisdiction have to be narrowly construed, and that involves both distinguishing cases where the dispute is not actually centrally about title, and distinguishing cases where the nature of the cause of action is personal, as in the case of the English exception to the Mozambique rule. Now, the second respect in which the European rule differs from the Mozambique and Hesperides principle as originally laid down is that in cases about disputes on land, the reason for it is not the maintenance of international comity, but the practical desirability of having disputes about land decided by a court, which is in a position to make whatever local inquiries may be required. And that was the point made in Webb and Webb, volume 3 of the Authorities Bundle, a decision of the European Court of Justice, which you will find at flag 13. And I think we can go to the two critical paragraphs straight away, which are paragraphs 14 and 16. Sorry, 14 and 17. Article 16 confers exclusive jurisdiction in the matter of rights in rem in immovable property on the courts of the contracting state in which the property is situated, in the light of the court's judgment in Reichert and Kotler, where the court had to rule on the question whether the exclusive jurisdiction prescribed by the article applied in respect of an action by a creditor to have a disposition of immovable property declared ineffective as against him on the ground that it was made in fraud of his rights by his debtor, it follows that it is not sufficient for Article 16.1 to apply that a right in rem in immovable property is involved in the action, or that the action has a link with immovable property. The action must be based on a right in rem and not on a right in personam, save in the case of the exception concerning tenancies of immovable property. The aim of the proceedings before the National Court is to obtain a declaration. Well, he then goes on to the facts of that action, and paragraph 17, as the Court has held, the conferring of exclusive jurisdiction in the matter of rights in rem in immovable property on the courts of the state in which the property is situated is justified because actions concerning rights in rem in immovable property often involve disputes frequently necessitating checks, inquiries and expert assessments which must be carried out on the spot. See the judgment in Sanders and Van der Putter. Now, that, therefore, is the first respect in which the rule has retreated. Since Hesperides Hotels, it has in some respects been overtaken by the rather different principles set out in the Brussels Convention. The other respect in which the rule has retreated is, of course, that Section 30 of the Civil Jurisdiction and Judgments Act 1982 introduced by statute the limitation of the common law rule for which the plaintiffs had unsuccessfully contended in Hesperides by making it applicable only to cases in which the real issue was the question of title rather than infringement, and the Section 30 will be found in Volume 1 of the Authorities Bundle, Flag 1, the jurisdiction of any court in England and Wales or Northern Ireland to entertain proceedings for trespass to or any other tort affecting immovable property shall extend to cases in which the property in question is situated outside that part of the United Kingdom, unless the proceedings are principally concerned with the question of the title to or the right to possession of that property, so that effectively aligns the common law rule with the rule for cases to which the Brussels Convention applied. Now, the next question, therefore, is, on what basis can the common law rule, either in its original or in its modified form, be extended to intellectual property rights? Now, the starting point, I would suggest, is that disputes about land are in some respects special. In most jurisdictions, and particularly in England, the attribution of title to land has historically been regarded as a fundamental aspect of sovereignty. Distribution of land was once the major foundation of political power. Title to land can therefore plausibly be regarded as based on an implicit grant of the sovereign in a way that is not true of other forms of property. Indeed, it is still, strictly speaking, the theory of landholding in England that even freeholds are a form of tenure from the Crown, and there is a corresponding rule in Scotland. Now, even in modern conditions, however, moving away for a moment from legal archaeology, rights over land may have important social implications, for example, for housing policy, so that legislation on the subject can fairly be regarded as having a large element of policy. And these are points which are made by Dicey and Morrison Collins in the current edition. If you turn back to the extract which we were looking at a moment ago, in Volume 4 at Flag 5, paragraph 23003, on page 1134 of the work. In a broad sense, the rule is based on a general principle found in most legal systems, that where the action concerns immovable property, the courts of the country where the land is situated have exclusive jurisdiction. The rule gives effect to the positive jurisdiction-conferring aspect of this principle. Rule 122 gives effect to its negative jurisdiction-denying aspects. There are various reasons for the principle. On the one hand, land still has a rather special position in most legal systems. On the other, there are practical considerations. Proceedings concerning land may involve inspections of property, and these can only be carried out in the court of the citus. And there's a reference to modern policy considerations in footnote 9 to that page. Now, that view, of course, is consistent with the speeches in Mozambique, where the whole analysis is based on the distinction between movable and immovable property. That was the basis of Lord Herschel's distinction between local and transitory actions and others. Disputes about land were local because of the particular characteristics of immovable property. They were not transitory. And in Hesperides Hotels, the plaintiff's claim for conversion of the movable property in the hotel was in fact held to be justiciable, and the appeal was therefore allowed in respect of the movables alone. Now, on any view, intellectual property rights are not immovable property. Section 90 of the Copyright Designs and Patents Act, which the Court will find in the loose leaf Supplementary Authorities volume at flag 1, is a brief section which provides that copyright is transmissible by assignment, by testamentary disposition, or by operation of law as personal or movable property.
Sorry, where is that?
It's at flag 1 of the loose leaf bundle of supplemental authorities which was supplied this morning.
Bundle 6.
I'm told it's been called Bundle 6. It's the first flag, Section 90 of the Act. Now, these are therefore personal incorporeal rights of the holder or his assignee. They may, of course, have a citus for the purposes of private international law, but then so do most movables, including incorporeal rights such as debts. Now, in our submission, there is in fact only one basis on which the reasoning underlying the common law rule about immovable property can rationally be applied to intellectual property rights. And that is that this is in reality an aspect of what we would now call the Act of State doctrine. The facts of both Mozambique and Hesperides were actually classic illustrations of the problem to which we would now regard the Act of State doctrine as being addressed. The Mozambique company claimed to have been evicted from mineral concessions in the Zambezi Basin, which it derived from a local potentate who was a surrogate of the Portuguese state. The British South Africa Company had received a royal charter to colonise the same area. The dispute, in effect, transferred to the English courts an international territorial dispute in the course of the scramble for Africa between Britain and Portugal. Hesperides was an attempt to obtain the decision of an English court on the lawfulness of expropriations of property in North Cyprus by the unrecognised Turkish government there. Now, so far as Act of State may be treated as at least one of the rationalisations of the common law rule about immovable property, then one can see an analogy with at any rate some intellectual property rights, namely those which may be said to depend on the grant of the state, for example, patents, and possibly registrable rights such as trademarks. Now that is in fact the basis of the distinction which we have seen in Article 22.4 of the Judgments Regulation a few minutes ago, where there is a distinction between rights derived from registration or deposit on the one hand, and other rights, and the validity of the registration or deposit on the one hand, and questions of infringement on the other. Those are distinctions that are written into Article 22.4 of the Judgments Regulations in relation to intellectual property. And that has been overtly rationalised in the Gennard report as a reflection of the principles governing the territorial autonomy and sovereignty of states. The relevant passage from the Gennard report can be found in Volume 3 of the authorities' volumes at tab 4, which is part of the commentary on Article 16 of the Brussels Convention, now Article 22 of the Judgments Regulation, and that says, under the heading Patents, 16.4 applies to proceedings concerned with the registration or validity of patents, trademarks, designs, and other similar rights, such as those which protect fruit and vegetable varieties, which are required to be deposited or registered. And skipping the next paragraph, since the grant of a national patent is an exercise of national sovereignty, Article 16.4 of the Judgments Convention provides for exclusive jurisdiction in proceedings concerned with the validity of patents. Other actions, including those for infringement of patents, are governed by the general rules of the Convention. Now, that is a rationalisation of the Mozambique rule, that it's concerned at least in part with acts of state, which would apply only to those intellectual property rights which depend on the grant of a foreign sovereign, and then only to disputes about the validity of that grant. It would not apply to copyrights and would not apply to infringement claims. Now, in the English common law world, the leading authority for the application of the rule about land to patents is the decision of the High Court of Australia in Potter and Broken Hill, which was one of the authorities approved by Lord Wilberforce in Hesperides, and that was expressly based on the Act of State doctrine. You will find the report of that case in volume 3 of the authorities volumes at flag 33. Now, this was decided at a time when in Australia patents depended on state legislation rather than on Commonwealth legislation, and the question at issue was whether a court in Victoria could rule on a challenge to the validity of the grant of a New South Wales patent. The plaintiff's suggestion was that that grant had been obtained in New South Wales by a misrepresentation. Now, the judgments are quite lengthy, and in the interests of saving time, I don't want to read the whole of them. If I can indicate where the critical parts will be found and refer you to the parts which summarise the ratio. The principal judgment was given by Chief Justice Griffiths, and at the bottom of the first page of the printout, you'll see that the question is whether it is competent for the courts of a state to examine the validity of an act purporting to be done by the supreme authority of another state in the exercise of its sovereign or quasi-sovereign powers. This question assumes, of course, that the grant of a patent is such an act. The matter has been very fully and ably argued, and we are much indebted to counsel for the assistance they have given us. There is apparently no decision either of the English or American courts directly on point. The question must be determined on principle. I will consider first what is the nature of a patent for an invention. It is sometimes described as an incorporeal personal property, a description which is sufficiently accurate for some purposes. It is no doubt personal property as distinguished from real property, and in that sense it may be described as a chattel. And he quotes Lord Herschel from Steers and Rogers, what is the right which a patentee has or patentees have? It has been spoken of as though a patent were a chattel or analogous to a chattel. The truth is that letters patents do not give the patentee any right to use the invention. They do not confer upon him a right to manufacture according to the invention. That is a right which he would equally effectually have if there were no letters patent. Only in that case, all the world would equally have the right. What the patent confers is a right to exclude others from manufacturing in a particular way and using the invention. The same doctrine has been laid down in the Supreme Court of the United States, which is a reference to Bloomer and McEwen, cited by the court in Bosch and Greff. There is no doubt also that this franchise or monopoly has no effective operation beyond the territory of the state under whose laws it is granted and exercised. In this respect, it partakes of the nature of an immovable as distinguished from a movable. It is true that the distinction between movables and immovables by writers on international law has never, as far as I know, been expressly applied to cases of patent rights. There can be no doubt that as the right is the creation of the state, the title to it must devolve, as in the case of land, according to laws imposed by the state. In two important particulars, therefore, it is analogous to an immovable. It differs from an immovable in that it is neither itself visible nor appurtenant to any particular thing that is visible and fixed within the state. It may perhaps be regarded in a sense as appurtenant to the whole territory. Such then being the nature of the right, how is it created? In my opinion, there can be only one answer to this question: by the exercise of the sovereign power of the state. And in due course, I would invite the court to read the rest of the judgment of Chief Justice Griffiths, but the essence of it can be seen from the parts that I have read. This is essentially regarded as non-justiciable because an attack on the validity of a patent is an attack on the sovereign act of the entity of the state which granted it. Similar views are expressed by the other members of the Court. Mr. Justice Barton, particularly at the outset of his judgment, which begins at page 5 of the transcript. Mr. Justice O'Connor, who begins at page 8 of the printout. In particular, perhaps, the lower half of the printout at page 9. Now, that decision was subsequently endorsed by the High Court of Australia in 1961 in a case called Norbert Steinhardt against Meth. I'm not going to take your lordships and my lady to that, though the reference is bundle 6 of the authorities bundle, the loose leaf one, at flag 6. The case is not directly relevant. It was another patent case in which the plaintiff was seeking in the Australian courts to restrain by injunction the making of threats in England to bring infringement proceedings on an Australian patent. And that failed because the Australian statutory provision dealing with threats to bring infringement proceedings had no application to threats which were being made outside Australia. That, of course, is a rather different point. Its only relevance for present purposes is that it considers Potter and Broken Hill and treats it as still being good law. Now, Potter was also, as I pointed out, cited with apparent approval by Lord Wilberforce in Hesperides, and indeed it was followed by Mr. Justice Laddie in a case called Coin Controls. Again, I won't turn to this, but it's at bundle 2 of the authorities bundles at flag 15. That was another case in which there was a challenge in England to the validity of foreign patents, although since the patents in question were Spanish and German, the outcome actually turned on the Brussels Convention. Now, the extension of the Mozambique rule to foreign intellectual property rights of any kind, even patents, has received some powerful academic criticism, in particular from Professors Fawcett and Torremans in their book Intellectual Property and Private International Law, which contains a sustained and very powerful criticism both of the extension and of the Court of Appeal's decision on jurisdiction in this case. I want to refer back to that later, but for the Court's note, the extracts in question are copied at volume 4 of the authorities bundle in flag 6. Now, Fawcett and Torremans, in summary, criticised the analogy with immovable property, and they criticised the application of the act-of-state doctrine as applied to intellectual property rights. A bald summary will not do justice to their views, which are argued with the benefit of a great deal of learning, both international and English. But in bald summary, the point that they make is that patents are not in any real sense a sovereign grant, because their grant is not discretionary. It's a right arising under the general law, in which the institutions of the state only come into it by virtue of having power to exercise an initial verification of a claim and a forensic adjudication afterwards. Now, I don't propose to take issue, I should make it clear, with the application of the Mozambique rule to foreign patents, because it is probably more satisfactory to leave that question to be answered in a case where it actually arises. It may well be that if such a case were to come before this court, the answer would be that the question was determined by reference to a principle corresponding to what is now Article 22.4 of the EU Judgments Regulation as representing the modern consensus of states on the limits of territorial jurisdiction. But that's a matter for another day. The sole intellectual basis on which this rule could be and has been extended to patents is, in our submission, plainly inapplicable to copyrights. And if I may make a number of related points in support of that proposition, first of all, I would respectfully suggest to the Court that it is highly unsatisfactory to apply a rule which is somewhat parochial in its practical implications to a field such as copyright, in which there are treaty arrangements designed to give effect to copyright internationally, and which indeed are internationally traded. The Berne Convention does not, of course, answer the questions before this court. The obligation of the states which are party to the Berne Convention is not to give effect within their own jurisdiction to foreign copyrights, but to allow foreigners the same copyrights as denizens would have under their domestic law. So the Convention doesn't answer the questions we're concerned with. But it isn't irrelevant because it does demonstrate that states do have an interest in the effective international enjoyment of copyrights. And there is, I would suggest, something odd about taking a principle which is designed to ensure that the English courts respect the autonomy of a foreign sovereign such as the United States, and then using that principle to frustrate the application of US copyright law to acts done in the United States by people over whom the English court alone has personal jurisdiction and whose wrongs would normally be justiciable here. There is, in our submission, no reason for the court to regard copyright as a field characterized by the kind of jealous assertion of exclusive jurisdiction which the House of Lords in Mozambique regarded as perfectly normal in the context of disputes about land. Now, the second observation which I should make about the particular position of copyrights is that while I accept that there is some arguable basis for applying the Mozambique rule to patents on the basis of the Act of State doctrine, there is no principled basis for applying it to copyrights. Not only are copyrights not immovable property, they are not dependent for their subsistence on either the explicit or the implicit grant of a sovereign in a foreign state. The position is that copyrights come into being automatically by virtue of the creative act of the author or artist without any intervention by the organs of the state. They do not depend upon a grant, even in abstract theory, but on principles of law of general application to whoever satisfies the conditions. Now, of course, a statute is, I suppose, a sovereign act, and the principles of law in question are statutory. But the same is true of any other statutory rule in one country which is justiciable in the courts of another country with personal jurisdiction over the defendant. For example, an action in tort for breach of a United States statutory duty by acts done in the United States, or an action on a foreign law contract where the relevant principle of foreign law is statutory, as in the case of illegality or certain implied terms. Now, copyrights do not even confer a public monopoly in the way that a patent does, because they don't protect the holder against independent creation by a rival. They only protect him against copying of his own work. And one can illustrate these particular points by reference to the issues in this case. All that we had to establish, and did establish at the trial before Mr. Justice Mann, which we did by calling experts on US law, was the terms of the relevant Act of Congress and the way in which it had been construed and applied by the US courts. None of that involved a challenge to any sovereign act of the United States, such as might arguably have occurred if we had been saying that the US Patent Office shouldn't have issued a patent or that it should now be rescinded. All that it involved was proving what the relevant US law was in exactly the same way as if we had been suing on any breach of statutory duty. Now, the third observation is this. The reasoning of the High Court of Australia in Potter is directed to challenges to the validity of a grant and not to questions of infringement. Although the rule in Mozambique was applied to questions of both title and breach, the extension to questions of breach was always controversial and it's pretty clear that it wouldn't have been accepted by the House of Lords in Hesperides if the matter were, as Lord Wilberforce put it, tabula rasa. It has now been modified by statute, manifestly in response to the decision in Hesperides, and it has also been modified in cases to which the Brussels and Lugano Conventions applied. Now, in my submission, the Mozambique rule, in its modern form, is reflected in Section 30 of the Civil Jurisdiction and Judgments Act and the EU Judgments Regulation. If one is going to apply it by analogy, then it should be in its modern form and not by analogy with the antique, illogical and redundant incrustations which disfigured it before 1982. Now, fourthly, it is, I would suggest, quite clear that in these respects the general consensus of civilized nations, which the House of Lords regarded as justifying the common law rule in Mozambique, simply doesn't exist in the case of copyright. Manifestly, it doesn't exist in the EU, 27 states, including major trading states with a very significant presence in the world of intellectual property rights. In the EU, there is no exclusive jurisdiction in respect of copyright at all, because they are not rights acquired by registration or deposit. In the EU, even where a right is subject to registration or deposit, exclusive jurisdiction vests in the country of registration or deposit only as regards challenges to the validity of that registration or deposit. Now, as a member of the EU, can the United Kingdom rationally apply one rule to intellectual property rights originating in one of the other 26 states of the Union, and a quite different rule to the whole of the rest of the world, and then stand up to claim that it is applying a principle based on the international consensus of all civilized nations about the limits of national jurisdiction? I suggest that the question answers itself. Now, in the United States, this question can fairly be described as controversial. Professor Nimmer, who is the author of what is, I think, generally regarded as the leading textbook on the US law of copyright, has cautiously supported the view that the only problems in the way of accepting subject matter jurisdiction over foreign intellectual property rights are, first of all, the act of state doctrine as applied to challenges to the validity of a grant, and secondly, forum non conveniens. And the relevant extract of his work will be found in volume 3 of the authorities volume at flag 11. No, it won't. Sorry, where is Professor Nimmer? It's 4. It's 4. Yes, I'm grateful. Could I invite the Court to turn to paragraph 1703, which is on the second page of the extract which has been copied. Even if the United States Copyright Act, he says, is clearly inoperative with respect to acts occurring outside its jurisdiction, it doesn't necessarily follow that the American courts are without jurisdiction in such a case. If the plaintiff has a valid cause of action under the copyright laws of a foreign country, and if personal jurisdiction of over the defendant can be obtained in an American court, it is arguable that an action may be brought in such a court for infringement of a foreign copyright law. This would be on the theory that copyright infringement constitutes a transitory cause of action, and hence may be adjudicated in the courts of a sovereign other than the one in which the cause of action arose. At least one court in a patent infringement action has held that a federal court may exercise jurisdiction and determine the merits of a claim of infringement under a foreign patent law arising out of acts occurring in a foreign jurisdiction. While other courts in patent and trademark cases have declined to exercise jurisdiction in actions for infringement under foreign laws, this has been based on the ground that may not be applicable in the case of actions for infringement of foreign copyright laws. Thus, in Vanity Fair Mills against Eaton, the court assumed that it was dealing with a transitory cause of action, but declined jurisdiction on the following rationale: were this merely a transitory tort action in which disputed facts could be litigated as conveniently here as in Canada, we would think the jurisdiction of the District Court should be exercised, but we do not think that the province of the United States District Courts to determine the validity of trademarks which officials of foreign countries have seen fit to grant. The Vanity Fair Court thus declined jurisdiction because it didn't deem it proper for an American court to pass upon the validity of administrative acts undertaken by foreign officials. By the same token, the Federal Circuit declined to exercise supplemental jurisdiction over foreign patents when domestic patents were already at issue. In that context, it quoted a provision from the Patent Cooperation Treaty to which the United States adhered. Nothing in this treaty and the regulations is intended to be construed as prescribing anything that would limit the freedom of each contracting state to prescribe such substantive conditions of patentability as it desires. Nonetheless, the ramifications for the copyright sphere appear to be distinct. Unlike foreign patent and trademark laws, and unlike United States copyright law, under virtually all foreign copyright laws, there are no administrative formalities that must be satisfied in order to create or to perfect a copyright. Pausing there, that is actually also the position in the United States now, because of the changes resulting from the requirement of the Berne Convention that adhering states should not impose procedural requirements. In adjudicating an infringement action under a foreign copyright law, there is then no need to pass upon the validity of the acts of foreign governmental officials. Based on this reasoning, the District Court in London Film Productions against Intercontinental Communications recognised the transitory nature of an infringement action premised on foreign copyright law, and on that basis sustained diversity jurisdiction over that subject matter. The plaintiff in that case, a British corporation, alleged that the defendant, a New York corporation, had caused 3 of the plaintiff's motion pictures to be televised in Chile, thereby infringing Chilean copyright law. The motion pictures were said to be in the public domain in the United States, but protected by copyright in both Great Britain and Chile. If other courts were to follow the lead of that lone ruling, the result would be to allow American authors to file suit in US courts for acts of infringement occurring abroad. It would also mean that foreign authors could sue unauthorized exploiters of their works in American courts for acts occurring abroad that constitute infringements of foreign copyright laws, even if such acts, had they occurred in the United States, would not be infringing. That last device would theoretically serve as a surrogate vehicle for attempting to enforce moral rights in the United States. Because other courts have typically declined to follow London Film on forum non conveniens grounds, among others, it remains an anomaly in the jurisprudence. But it is not completely alone. 16 years later, the same court once again accepted diversity jurisdiction over such claims. And that's a reference to Armstrong and Virgin Records. Both London Films and Armstrong are copied in the authorities' bundles before the court. Now, other writers have disagreed with the cautious endorsement of that view expressed by Professor Nimmer. In particular, Professor Patry, the author of the great rival work on US copyright law, disagrees with it, and there is also a dissent from it expressed by the author of an article in the Cornell Law Review. Both of those will be found in the bundles before the court. Patry is at volume 3, flag 6. But interestingly enough, the American Law Institute has recently come out unequivocally in favour of cross-border jurisdiction over intellectual property disputes in a report which benefited from the input of a distinguished panel of advisors and jurists from the United States, Canada, Britain, France, Germany and Japan, one of the British representatives being, interestingly enough, Lord Justice Jacob. Now, if the court would turn to Bundle 6, the loose-leaf bundle of supplemental authorities, and turn, I'm sorry that this is copied in 2 separate places, but the principle endorsed by the American Law Institute appears behind flag 4, in section 211 of the work. The title, you can see what it is from the first page of this. Section 211, except as provided in subsection 2, a court is competent to adjudicate claims arising under foreign laws pertaining to the subject matter of these principles, i.e. intellectual property rights. However, with respect to each asserted claim, the court must have subject matter jurisdiction under its local law and personal jurisdiction. And the reference to subject matter jurisdiction under the local law is to the court being an appropriate court to decide that kind of issue. For example, if you have a copyright tribunal in a particular jurisdiction, you may not be able to sue in the ordinary courts and so on. Now, under the commentary, which follows, B, subject matter jurisdiction over registered rights, or perhaps I should start with A, each state controls the reach of its court's authority over the subject matter of disputes. For example, the principles cannot alter a rule that limits the court's power to entertain foreign intellectual property claims. However, the efficiency goals underlying the principles are best effectuated when the rules on adjudicatory authority are broad enough to encompass foreign claims. In cases where such authority is unavailable, however, the principles provide a mechanism for cooperative adjudication. Subject matter jurisdiction over registered rights, there is substantial sentiment that issues regarding the validity of a registered right, particularly a patent right, should be adjudicated in the courts of the state where the right is registered. Only this state is competent to cancel the registration. Furthermore, there are regional agreements that confine adjudicatory authority to the state of registration. Some states further channel validity disputes into special fora. These states are willing to accept bifurcated adjudication because the issue of infringement will be determined more quickly and this could promote settlement. Nonetheless, the principles do not include a blanket prohibition on the adjudication of matters involving a foreign state's registered rights, because separating adjudication of validity from infringement can have substantial ramifications. Separate resolutions can prevent a court hearing all of the evidence relevant to its action and from using its understanding of how a technology is utilized to inform a decision on the scope of the rights. And the other section of the ALI report, which the court should look at, is in volume 4, at flag 9. You'll see the list of advisors on the second page of this. And over the page, under the heading Introduction, they make the point in general terms that there is a need for a less parochial attitude to these matters given the global trading of copyrights and artifacts based on copyrights. But I am primarily referring to it for what one finds at page 23, which is part of the general introductory section of the report under the heading Local Against Transitory Actions. Some courts have justified the dismissal of intellectual property claims arising under foreign laws on the ground that intellectual property actions are local, not transitory causes. The principles reject that theory. In registered rights cases, however, the local characterization is more compelling when the issue concerns the validity of the registration, because only the state that has registered the right has the power to cancel the registration. This kind of local action is more properly conceived as an iteration of the active state doctrine. The jurisdictional analysis would be more coherent if courts were to forego the local and transitory appellations and focused instead on the sovereign interests captured by the active state doctrine. Nonetheless, in Voda and Cordis Corporation, a panel of the Federal Circuit, over a powerful dissent by Judge Newman, assumed arguendo that the Act of State doctrine applied and held that patent infringement claims could be considered local actions. Now, just pausing there, Voda and Cordis is in fact copied in Volume 3 of the Authorities Bundles, and it's a case which Lord Justice Jacob in the Court of Appeal regarded as of great interest. The problem about relying on it in this case is, first of all, that Voda and Cordis was concerned with patent actions and therefore with something which is capable of analysis in terms of sovereign grant. Moreover, if one reads Voda and Cordis, it's absolutely plain that the whole analysis of the sovereign interests involved was part of a discussion of what we would call forum non conveniens. It's under the heading discretion, and it deals with the practicality and desirability, rather than the absence of jurisdiction, to determine such matters. Now, moving beyond the common law world, we've looked at the EU, at the United States. It's right to point out that Fawcett and Torremans identify a number of other jurisdictions which routinely accept jurisdiction in respect of foreign intellectual property rights. If the court would take up bundle 4 of the authorities and turn to flag 6, paragraph within the work, this is the latest edition of Fawcett and Torremans, which came out about 3 weeks ago. Paragraph 6.195, page 311 of the work. Thirdly, the limitation is not in the interests of the English courts, in that it is unnecessarily rules out England as a venue for international litigation concerning intellectual property rights. Putting it bluntly, the English courts and lawyers are losing out on business. Courts abroad are not always so unwise. Well, now, I'm not going to invite this court to act as a trade protection union for the English bar, but what matters for this purpose is the observation about other courts that take a more international view of these matters. The Dutch courts are happy to adjudicate upon infringements concerning foreign intellectual rights that have been infringed abroad, and have granted injunctions not only in respect of intellectual property rights granted in other EC member states, but also in respect of those rights granted in other states. In Finland, the Helsinki Court of Appeal has taken jurisdiction in a case involving the infringement of trademarks registered in Brazil and Russia. Moving outside Europe to the United States, although the concept of subject matter jurisdiction is well known and applied, at least in patent and trademark cases, there is a well-known example of a court taking jurisdiction in a case concerning the infringement of a British copyright in Chile and other South American countries. That's a reference to the London Films case. Japanese courts are prepared to try actions relating to the infringement of foreign patents. Now, why does all this matter? The reason it matters, I would suggest, is that if you are going to say that a court which has personal jurisdiction over the defendants must decline to adjudicate on a foreign copyright, even though the plaintiff can get justice nowhere else, if you're going to say that, and to say that in that way, intellectual property rights differ from almost all other civil wrongs governed by the law of a foreign country, then you have to put forward some principled justification for that result. The only principled reason which has ever been put forward in cases about land, apart from the Act of State doctrine, which has no application to copyright, is that this is the limit which the consensus of nations places upon the territorial reach of national courts. But where is that consensus? If the EC, the United States, Finland, the Netherlands, and other countries referred to in Fawcett and Torremans actually act on a different rule. If there is no consensus, why should the courts of the United Kingdom not apply exactly the same principles of private international law as they apply to the generality of civil wrongs? Now, before the decision of the Court of Appeal in the present case, there were 4 English cases dealing directly with the application of the Mozambique rule to foreign copyrights. And they were Tyburn Productions and Conan Doyle, a decision of Mr. Justice Weinlot, Pearce and Ove Arup, a decision of the Court of Appeal, Griggs and Evans, a decision of Mr. Peter Prescott, QC, sitting as a Deputy Judge of the High Court, and more recently a decision of Mr. Justice Flo in a case called Satyam Computer Services. Unfortunately, these cases point in different directions, but I ought to refer the Court to the critical parts of them. Tyburn Productions and Conan Doyle, which was the first of them, is at Volume 2, Flag 31, and this remains the only case, apart from the present one, in which it has been held that claims in respect of a foreign copyright were non-justiciable because of the Mozambique rule. Now, It came before Mr. Justice Beinlott on a rather odd procedural basis. It was a claim for a preemptive declaration that the defendant, who owned the United States copyrights in the works of Sir Arthur Conan Doyle, had no such rights, apparently anywhere in the world, as would entitle her to prevent the distribution of a film featuring Sherlock Holmes and Dr. Watson. The claim was rejected on two distinct grounds. First of all, that the issue was non-justiciable, and secondly, that an injunction should be refused in any event as a matter of discretion, because the question was academic, there was no actual dispute, and anyway, the decision of the English court would not be regarded as decisive in the courts of other jurisdictions. Now, as far as the first of those reasons, justiciability, is concerned, the value of the case's authority on the issue before the court now is somewhat diminished by two circumstances. The first is that it was conceded that the rule in relation to patents applied generally to all intellectual property rights, a concession which in my submission was wrong. The case was therefore argued on the basis that Potter was wrong to extend the Mozambique rule even to patents. It's also diminished, perhaps, by the fact that Mr. Justice Beinlott did not, in his judgment, address the distinction between challenges to validity and claims for infringement. It seems that that point may not have been argued either, so that neither of the critical points for present purposes was considered. If the court would take the report of the case, I will just identify briefly the relevant passages. In the internal numbering at page 80, on page 5 of the printout, halfway down the page, just below, the central issue in this case is whether the distinction between transitory and local actions, which was considered by the House of Lords in Mozambique, was fundamental to that decision, and if it was, whether an action raising questions as to the validity or infringement of patent rights, copyrights, rights of trademarks and other intellectual property rights are properly to be considered actions of a local nature, or whether that distinction was, as it were, an historical prologue setting out the basis of the narrower rule that the English courts will not entertain proceedings raising questions as to title to or trespass to land. And at page 84 in the internal numbering, page 8 of the printout, the court will find the concession after the last break in the page, following the quotations. It's accepted by Mr. Rayner James that no distinction can be drawn for this purpose between patent rights, copyright, and rights of trademarks and other intellectual property rights. And a few lines further down, he accordingly invited me not to follow Potter and Broken Hill Proprietary, or the more recent decision in Norbert Steinhardt, where the High Court of Australia applied the same principles to threats. And passing over the analysis, which is based on cases that your lordships and my lady have read, page 88, page 12 of the transcript, or the printout. In my judgment, therefore, the question whether the defendant is entitled to copyright under the law of the United States of America or any of the states of the United States is not justiciable in the English courts. Mr. Rayner James accepted, rightly I think, that if this question is not justiciable in the English courts, then in the light of the decision of the House of Lords in British Airways and Laker, the claim for an injunction and a declaration must fail. And his conclusion on discretion, though he then refers to Mr. Hobbes's other argument about discretion, and his conclusion on that at the top of page 13 of the printout is, in the instant case, there is no evidence that if the validity of the rights claimed were justiciable in the English courts, the decision of the English courts would be treated as binding on any of the states in the United States of America, and it would, in my judgment, be an exercise in futility to allow these claims, which raise complex issues which may require a survey by the English courts with the assistance of experts of the laws of each of the states of the United States of America to continue. Now, the next case was Pearson over Arup, a decision of the Court of Appeal, which reviewed the same cases but reached a different conclusion about them in a case where no corresponding concession was made. Now, that case is again in volume 2 of the authorities volume at flag 26. Now, in this case, the Court of Appeal held that the English rules of private international law did not require them to decline jurisdiction over claims in respect of infringement of Dutch copyrights by acts done in the Netherlands. Now, the case was governed by the Brussels Convention, under which copyrights were not within the exclusive jurisdiction of the country of origin, so jurisdiction was therefore founded on the general rules under the Convention. Nevertheless, the Court went in with some care to the scope of the common law rule, because although the Court held that the fact that the Convention conferred personal jurisdiction on the courts of England carried with it subject matter jurisdiction, that was essentially what the argument was about, what was suggested is that even in a case where the Convention assigns jurisdiction to, say, England, it is still incumbent on the English court, although it has personal jurisdiction under the Convention, to decide whether it has subject matter jurisdiction over any particular issues. Now, Mr. Justice Lloyd, who heard the case at first instance, had held that the common law would have made the action non-justiciable, but that the Convention overrode the common law in that respect. The Court of Appeal dismissed the appeal, but they did so on a different basis. They considered that there was in fact no inconsistency between the Convention and the common law rule, because in its modern form, the common law rule was limited in the same way as Article 16.4 of the Brussels Convention, now Article 22.4 of the regulation. So they held there was no difference between them. And in the course of a careful analysis of the English authorities, which we have examined, they reached a number of conclusions relevant to the present issue. Now, obviously, by taking gobbets, I'm in danger of missing part of the context, though I shall try not to. But if, in the interests of time, I may just identify the critical parts of this judgment by reference to a number of propositions which they endorsed. First of all, the Court of Appeal considered that the Mozambique case was based on the fact that under internationally accepted consensus on private international law, disputes about land were within the peculiar province and competence of the state where the land was. And that point is made at page 431, page 23 of the printout, page 24, of the printout, after the first break in the page. It is, we think, clear from an analysis of the judgments in the Mozambique case that the House of Lords treated the question whether the English courts should entertain an action for trespass to foreign land as one of justiciability. The English courts should not claim jurisdiction to adjudicate on matters which, under generally accepted principles of private international law, were within the peculiar province and competence of another state. And there's a citation from Vattel. Secondly, the Court of Appeal in this case regarded Potter in Australia as authority for the application of the Act of State doctrine to intellectual property rights, which depended on sovereign grant, which of course was the same principle, according to Jennard, that underlies Article 16.4 of the Brussels Convention. And that point can be found at page 435 and 436. This is page 27 of the, 35 and 36, page 27 of the printout. After the last break in the page, the principle that the courts of another contracting state should not make inquiry into the validity of a patent or into the registration or validity of a similar intellectual property right is, of course, recognised and preserved by Article 16.4. That this exclusive jurisdiction is based on considerations of sovereignty is made clear by Jennard, which is quoted, where proceedings are concerned with the registration or validity of patents, trademarks, designs, or other similar rights required to be deposited or registered, the local court has exclusive jurisdiction. But where the action is not concerned with registration or validity, the Convention gives jurisdiction to the courts of the defendant's domicile or to the courts of another contracting state. The question, can the English court inquire into the validity of a patent granted by a contracting state, is answered by Article 16.4. The question, does the English court have jurisdiction to entertain proceedings in respect of alleged infringements of an intellectual property right, is answered, conferred whether proceedings fall outside Article 16.4, is answered by Articles 2, 5 or 6. And they then go on to deal with or refer to the Potter case. There is, in our view, nothing in the reasoning of the High Court of Australia in Potter which requires the answer no, notwithstanding the proceedings fall outside 16.4 and that the English court has jurisdiction to entertain the proceedings. The English court must nevertheless decline jurisdiction because the question is non-justiciable. We will also refer to Norbert Steinhardt, same point. The logic, if we may say so, is beyond criticism. No action could be maintained in Australia in respect of what was done in England because neither the Australian Patents Act nor the English Patent Act had an extraterritorial effect. Now, the point that's being made there is that the Australian jurisprudence is exactly in line with the Brussels Convention in the relevant respect.
This page confirms something that was puzzling me. I didn't realise the High Court of Australia ever sat by a single judge, but it evidently did in Norbert Steinhardt.
It did, and I don't know what the reason for that was. I was under the same impression.
I was wondering whether we'd got the wrong report, but evidently we haven't.
No, there is obviously a jurisdiction to do this, and I'm not quite sure on what procedural basis, but it obviously exists. Now, thirdly, the Court of Appeal in Over Arab considered that the application of the Mozambique rule to claims for damages, where the existence of the right was not the real issue, was no longer appropriate after the enactment of the Civil Jurisdiction and Judgments Act. And that is a point made in the internal numbering at page 432, page 24 of the printout, where they refer to the second limb of the rule in the Mozambique case and to its overriding last paragraph on the page 24 of the printout by the Civil Jurisdiction and Judgments Act. Fourthly, the Court of Appeal considered cases with which we have not troubled this court, like Def Lep in England and Norbert Steinhardt in Australia, irrelevant because they were cases where the issue was whether you could sue in the United Kingdom for an infringement of English copyright law abroad. And the answer was obviously not, because of the territorial limits of the English statute, and that those were therefore not cases that were of any assistance. And for the court's note, that will be found in the internal numbering, pages 437 and 437, and over the page to 8. Fifth and lastly, the Court of Appeal in this case appeared to have doubted whether Mr. Justice Weinlott's decision in Tyburn Productions was rightly decided, but they left the question open. See pages 439 and 440 of the judgment, page 30 of the printout, bottom full paragraph on that page of the printout. They left the question open because the result in Mr. Justice Weinlott's case was quite plainly justified on the second of his grounds, namely that the issue being academic, that relief should be refused as a matter of discretion. Now, what one finds in this case, and what makes it interesting, is that each stage one sees the Court of Appeal pointing out that the common law rule, in its modern form, post-1982, corresponds to the rule laid down in the Brussels Convention. And their conclusion was that the claim in respect of infringements of Dutch copyrights in the Netherlands was justiciable, not, as Mr. Justice Lloyd had held, because the Convention overrode the common law, but because the Convention and the common law in modern conditions were saying exactly the same thing. And that's the reason why they refused a reference, see page 445 at the very end of the report, under the heading "The Need for a Reference to the Court of Justice." It was submitted that the respondent's notice raises questions on which we should seek rulings from the ECJ. These questions were not formulated, but in substance they are whether the rules of English private international law, derived from the Mozambique case, and Phillips and Eyre, are in conflict with and must yield to the basic principle embodied in Article 2 of the Brussels Convention that a defendant must, subject to the special jurisdictions of the Convention, be sued in the country where he is domiciled, and 2, whether by reason of Article, this point about the Berne Convention, and then after that point, we are satisfied that it would not be appropriate to make a reference in this case. We're not persuaded that the first of the 2 questions identified above is, on a true analysis, a question of European Community law or a question of interpretation of the Brussels Convention. In our view, it is properly to be regarded as a question which turns on the policy underlying the relevant rules of English private international law. In other words, because English private international law would not make it non-justiciable, there was no reason to ask the English court whether that was consistent or inconsistent with the Convention. Now, Griggs and Evans is in the same volume at flag 29. Now, this case arose out of a contract between the claimant and the first defendant, which was governed by English law, and the contract contained, as the judge held, an implied term that certain foreign copyrights would belong to the claimant. The first defendant, notwithstanding that, had purported to assign the foreign copyrights to the second defendant, and the judge held that in equity the title remained with the claimant. The issue which the judge had to decide was whether the English court was prevented by the Mozambique rule from ordering the legal owner of a foreign copyright to assign it to the beneficial owner. And he held that that was not prevented by the Mozambique rule. Now, the decision was actually based on the established exception to the Mozambique rule, which I mentioned a while ago, for personal obligations relating to land, or if you apply it to copyrights, then to copyrights. But the judgment is important for this reason. First of all, of course, Mr. Prescott is a notable authority on the subject, and his judgment contains a very penetrating and refreshingly readable and flamboyant analysis of the Mozambique rule as applied to intellectual property rights in modern conditions. Now, I'm not going to read more than very selected parts of it. What I will do, if I may, is point the court to the sections which deal with this whole issue for more leisured reading later. The relevant part of the judgment starts at paragraph 62, and the significant paragraphs are between paragraphs 72 and 87 and 117 and 193. And all I will do on my feet is to identify the 5 principal points for which I say its authority, and the particular passages which are critical for that purpose. First of all, Mr. Prescott considered that the only part of the ratio of Mozambique which survives today is that it's a breach of international comity to try a question of title to foreign land, except incidentally. And that will be found summarized at paragraphs 72 to 74 and paragraphs 77 and 78. If you look at paragraph 74, bottom of page 18 of the printout, hence it must be clear that the proper justification for the Mozambique rule cannot rest on a general proposition that our courts do not entertain disputes concerning the existence or scope of laws made by a foreign sovereign. They do it all the time. This is so even if the courts of that country are themselves at odds on the very same question. And over the page at paragraph 77, opposite, so the reason it is perfectly in order for our courts to decide that the defendant has misappropriated or dispossessed chattels situated in a foreign state, contrary to the laws of that state, to decide that the defendant is liable for personal injuries or damage to property inflicted by his breach of the local road traffic or ship navigation laws, to decide that A but not B shall succeed under an English will made by the owner of foreign land, or to order that X must convey land to Y situated in a foreign state in accordance with its obligation, must be because, according to the usages of nations, it is not considered to be a breach of comity to do these things. And at paragraph 80, under the heading International Developments, the question resolves itself into discovering what is internationally acceptable, what may not have been acceptable in 1908, may be so in 2004. The second point for which Mr. Prescott's decision is authority is that land is special for a variety of social, economic and historical reasons, which he summarises pithily at paragraphs 117 to 119. Particularly paragraph 118. According to deeply held notions of mankind, the surface of the earth has a very special, I am almost tempted to say sacral character, which cannot be said of most intellectual property. Even as I write, there are men and women who are prepared to kill or maim innocent people, all because of what an outsider might call a tract of arid desert or mountain. Yet who would perhaps scorn to do so over money of equivalent value? In former times, ownership of land might confer obligations of a military character. In unruly times, the very puissance of the sovereign might depend on his ability tightly to control land ownership. Later on, lone ownership of land might confer a right to vote or to seek election to a legislature. And he goes on to refer to the movable status of intellectual property rights. Thirdly, the judge makes the point that the Brussels Convention is not just relevant to cases where it directly applies, it's also relevant as showing the changing consensus of nations concerning these matters as regards both land and intellectual property rights, a point which I have made in the course of my submissions. And that the Court will collect from paragraphs 80 to 82, and from paragraphs 123 to 126. In particular, if the Court looks at paragraph 123, the significance of Article 16.4 of the Brussels and Lugano Conventions, respectively. Doubtless those conventions were not cited to Mr. Justice Weinlock because their relevance wasn't perceived, seeing that the United States is not a party. Nor was it very likely that their relevance would have been perceived at that date, when we were unaccustomed to the novel concept that in certain circumstances a claim for infringement of foreign copyright not only may but must be brought before the English courts. I have already reviewed matters touching Article 16.1, which concerns foreign immovables, and have felt them to be a useful source of evidence concerning developing international practice about judicial comity in such cases. I consider that the same approach may be useful with regard to Article 16.4, which concerns foreign intellectual property. And paragraph 125, while it is true that the decision of the Court of Justice was not concerned with the laws of those countries which were not parties to the Convention, I nevertheless regard it as helpful evidence of modern international practice. Fourth, the judge observed that it is important to bear in mind that since the decision in Mozambique, the English courts have developed a coherent doctrine of forum non conveniens. This, of course, was a point that was also made by Lord Wilberforce in Hesperides at a stage when that doctrine had not yet been fully incorporated into English law. Now, the considerations, therefore, that justified the decision in Mozambique would, in the judge's view, be more satisfactorily addressed to the exercise of the discretionary function of the court under that doctrine. And that is a point which Mr. Prescott makes between paragraphs 84 and 87 of his judgment. Finally, and fifthly, between paragraphs 134 and 139, there is an extended analysis of Mr. Justice Weinlock's decision in Tyburn Productions, in which he concludes, as the Court of Appeal did in Pierce and Over Arra, that it was of little assistance because of the limitation of the issues he was called upon to decide and because of the concession in particular. There is finally the decision of Mr. Justice Flo in Satyam Computer, which will be found in the same volume at flag 30, the next flag. Now, the issue in this case was whether the claims on the US copyrights for certain computer software were excluded by the terms of a settlement agreement. And in the course of argument on that point, the question was raised whether the claims which were said to be excluded would be justiciable in England. The judge in fact held that that issue didn't arise. He could decide the matter on the construction of the settlement agreement. But extensive argument was addressed to it, and he therefore considered it obiter between paragraphs 91 and 102. And simply to take the critical parts of the reasoning, paragraph 91, the case put forward by Upaid is that this court does not have subject matter jurisdiction over the Texas claims by virtue of the application of the Mozambique rule. And across the page to paragraph 94, as to the application of the common law rule to claims in respect of foreign intellectual property, I have considerable doubts whether the rule in its wider form, developed in the Hesperides Hotels case, ever applied to intellectual property, and I agree with Mr. Boswood that a now abrogated rule at common law is a somewhat shaky basis for such a wide proposition of law as that advanced by Upaid. Upaid's case in this regard is founded on the decision of the High Court of Australia in Potter. So far as Potter is concerned, of course, like so many decisions of that court, it is well reasoned and entitled to great respect. But I agree with the reasoning of the Court of Appeal in Pearson over Arup that while Potter supports the principle that the English courts should not make inquiry into the validity of a foreign patent or similar intellectual property right, it does not support any wider principle. In particular, there is nothing in the reasoning of the High Court of Australia which requires the English court to find that a claim for infringement of a foreign patent is non-justiciable where there is no issue as to the validity of the patent. And then moving on to 97, it's not clear whether the judge, this is in the Conan Doyle case, Mr. Justice Weinlot's case, was deciding that an action for infringement or a foreign intellectual property right was not justiciable in an English court, even if no question as to the validity of a foreign right was in issue. It's the main reason why he thought it of limited assistance. And over the page, paragraph 98, I have underlined the section at the end of the passage from the Court of Appeal in Over Arup because it seems to me of some importance. Although the Court of Appeal fell short of saying that Tybon Productions was wrongly decided, they clearly thought that its application should be limited to cases where the existence or validity of the foreign patent was in issue. They did not consider it to be authority for the proposition that a claim for infringement of a foreign patent was not justiciable in England if the validity of the patent was not in issue. And one can then get the essential point that he makes by way of conclusion from paragraphs 100 to 102. Coin controls, this is the decision of Mr. Justice Passy about the justiciability of patents. So paragraph 100. Coin controls was cited to the Court of Appeal in Over Arup, but is not referred to in the judgment. Nonetheless, to the extent that Mr. Foxton seeks to rely on it in support of a broad proposition that a claim for infringement of a foreign intellectual property right is not justiciable in England, I agree with Mr. Boswood that the decision of the Court of Appeal in Over Arup casts serious doubt on such a broad proposition. I also note that in a subsequent decision in the Chancery Division of Peter Prescott QC in Briggs and Evans, the learned deputy judge doubted whether the rule applies to intellectual property at all, a view which appears to find favour with the editors of Dicey, Morris and Collins. I would be reluctant to go that far, not least because the Court of Appeal didn't do so in Over Arup, despite the opportunity. However, in my judgment, the Mozambique rule as it applies to foreign intellectual property rights should be limited to those cases where the existence or validity of such rights are in issue, and it is only in such cases that a claim for infringement of the rights should not be justiciable in England if English jurisdiction can otherwise be established. It is only where the English court is being asked to adjudicate on the existence or validity of a foreign patent that, as I see it, the rationale of the Mozambique rule comes into play, namely the public policy that it's undesirable that English courts should adjudicate on issues which are essentially foreign and local. See Mr. Justice Laddie in Coin Controls. What is at issue is the infringement of the relevant intellectual property right and the damage suffered by the claimant as a consequence. Why should the English courts not assume jurisdiction which they otherwise have in respect of a relevant foreign tort? Now, I have referred the court only to the conflicting English decisions, but I will give references to other material. There are decisions in other common law jurisdictions. The problem, unfortunately, is that they have tended to follow whatever is the latest decision in England, and the English decisions have moved to and fro. That is why there are inconsistent decisions in New Zealand. In New Zealand, one case has decided has followed Tyburn Productions, and another case has declined to follow it. The court will find references to those in note 23 of our printed case, and the cases in themselves will be found in due course in volume 3 of the authorities bundles at tabs 17 and 28. One is a case called Atkinson Footwear, and the other is a case called Sony Computer against Van Dien. There is also one very recent decision of the Supreme Court of South Africa, which has followed the Court of Appeal's decision in Lucasfilm itself. That will be found in due course. I'm not going to take time by turning it up. At flag 25 of bundle 3. The judgment is very brief, and it has little in the way of independent discussion of the issues, but it does correctly summarise what the Court of Appeal decided. As far as textbooks are concerned, there is a brief and neutral analysis of the issues in the current edition of Dicey, Morris and Collins at paragraphs 35.028 to 35.033. The court will also find an extended discussion of Tyburn Productions and a trenchant criticism of the extension of the Mozambique rule to any intellectual property rights, i.e. it goes further than I have done, in Fawcett and Torremans, which has been copied in volume
4 tab 6.
4 tab 6, paragraphs 6.152 to 6.227 are the critical paragraphs. The authors of that work suggest, as Mr. Prescott did, that the relevant policy considerations underlying the rule should be treated as factors going to the discretion to stay actions under the forum non conveniens doctrine and not as going to justiciability. Now, in the present case, the Court of Appeal dealt with the question of jurisdiction at paragraphs 99 to 186 of the judgment, and the critical parts which summarise the reasoning are between paragraphs 175 and 183. If I could ask the Court to cast a brief eye down paragraphs 175 to 183, which summarises their reasoning, just to remind yourselves of what they said. Now, in summary, they gave 7 reasons for their decision. Now, some of those reasons at first sight look like legal reasons, and some are based on the supposed practical difficulties of receiving claims for foreign intellectual property rights. The apparently legal reasons appear to be these. First, they say, paragraph 175, that both limbs of the Mozambique rule, including second limb, which was abrogated by statute, should be applied by analogy to intellectual property rights. Secondly, they say at paragraph 181, little Roman 3, that for the purposes of justiciability, all intellectual property rights are the same. And thirdly, they say at 181, little Roman 4, that in any event, it's really rather artificial to say that questioning the validity of a registered right is somehow impugning the powers of a sovereign state, the grant of a registered intellectual property right is governed by laws. All one is doing when challenging the validity is to say that the right was wrongly granted according to law. Sovereignty in any realistic sense doesn't come into it. Now, these three...
They cut both ways, don't they, these comments?
Sorry, Miller?
They cut both ways.
Well, they do indeed. The real problem, they are bold assertions not sought to be justified by reference to either authority or principle. But the problem is that if sovereignty doesn't come into it, as the learned Lord Justice suggests, then on what basis is the Mozambique rule said at paragraph 175 to apply by analogy to intellectual property rights, given that the Mozambique rule is all about the comity of nations and the mutual limits of sovereignty? If you reject, as the Court of Appeal appears to be doing, the legal rationale of the Mozambique rule as applied to intellectual property claims, then you are actually left with no principled justification whatever for a rule of non-justiciability other than purely practical considerations as spelt out in the rest of this part of the judgment. Now, the difficulty about that is that the practical inconveniences of the English courts hearing intellectual property disputes originating abroad are in our submission both illusory and actually irrelevant. We can take as an example the suggestion at paragraph 175 of the judgment that intellectual property rights are essentially local matters to be decided by local judges, which in one sense essentially encompasses most of the points made in the rest of that section of the judgment. Now, that is not in our submission a real problem, because the subsistence of intellectual property rights, their existence or non-existence, is not a matter of discretion, as Lord Justice Jacob himself points out. They are matters of law in every civilized intellectual property jurisdiction, including the United States. So far as questions of policy are involved in them, they are reflected in the law, invariably in legislation, just as they are in actions for damages for breach of a foreign statutory duty. And you can prove the foreign law which gives rise to intellectual property rights in exactly the same way as you can prove any other statutory right. What does it matter, taking up the comment made at paragraph 176 by Lord Justice Jacob, what's it matter if the legal policies of different jurisdictions may be different, if the differences are embodied in ordinary legal sources and can be established by expert evidence? The English courts do this absolutely every day in different contexts. Now, it's not only an illusory problem, but I submit that it would be an irrelevant problem even if it were substantial. And that is because there cannot be any justification for saying that United States copyrights should be for United States judges when the matter cannot be brought before a United States judge in a manner that will be recognized in England, because Mr. Ainsworth and his company are not amenable to the personal jurisdiction of the US courts. Now, Lord Justice Jacob may or may not be right in saying that it's desirable that the matter should be tried in the United States courts. But with respect, it cannot be right to say that if the action can't be tried in the United States courts, it follows that it should be tried nowhere at all. And yet that is the consequence of treating this as a matter going to justiciability, rather than treating it as a matter going to forum non conveniens. The absoluteness of treating it as a matter going to justiciability means that even if you can't achieve the desirable result of having it all tried before a US judge, no justice is done anywhere at all. And the same point can in fact be made about all of the other practical reasons put forward by Lord Justice Jacob in the following paragraphs of this judgment. They may, arguably, be good reasons for having the United States copyright claims decided in the United States if there's a choice of forum, but they cannot possibly be good reasons for having it tried nowhere at all and leaving the copyright holder with no remedy for what is now an admitted breach. Now, I would suggest that it is particularly absurd for the learned Lord Justice to suggest, as he does in this section of his judgment, that accepting jurisdiction would encourage forum shopping. In general, the remedy for forum shopping is for the court to decide on the appropriate forum, as it always does in forum non conveniens applications. But in the present case, the danger of forum shopping is non-existent, because we're dealing with a case where there is only one possible forum, and that's the forum to which the Court of Appeal is denying us access. Now, in some ways, I would suggest it's even odder for Lord Justice Jacob to be suggesting, as he does at 1813, that it's impractical to adopt any principle which involves distinguishing between the validity and infringement of an intellectual property right. The learned Lord Justice says that with a view to suggesting that both of them should be treated as non-justiciable. But the problem about that is that the distinction between validity and infringement is written into the EU Judgments Regulation and the Lugano Convention. In the context of land, it's also written into Section 30 of the Civil Jurisdiction and Judgments Act. It cannot be impractical or undesirable to do that which the law requires the court to do.
It's easy to see how the distinction applies to patents. How does it apply to copyright?
Well, of course it doesn't. It applies in a purely pragmatic sense to patents, because in most patent actions where there is an infringement allegation, the patent is alleged to be too wide or whatever, and therefore to be invalid in the relevant respect, and they can be two sides of the same coin as a matter of evidential investigation, not as a matter of legal principle. But although for that reason it may be convenient to an English lawyer to have them tried together, it's worth bearing in mind that there are jurisdictions, notably Germany, where the validity of a registrable intellectual property right is obligatorily referred to a public law tribunal, while questions of infringement are obligatorily decided by the ordinary courts. Now, the truth is, it may be inconvenient to separate them, and that may well be a relevant factor in a debate about forum non conveniens. But it's simply not right to say that the exercise can't be done, and certainly not right to regard it as going to justiciability. Now, I wouldn't quarrel with Lord Justice Jacob's view that it would be desirable, if it could be done, to deal with all of these matters in an international convention which was wider than just the ones covering the EU and EFTA countries. But we have to ascertain what the law is in the absence of such a convention, because that's the situation where we are in. If I were you, I wouldn't start from here, is not a helpful proposition in law. There are existing principles of English law which govern the exercise of jurisdiction over persons who are personally amenable to the jurisdiction of the English courts in respect to foreign civil wrongs, unless, of course, the action is stayed on grounds of forum non conveniens. But if they have not been altered, if those ordinary principles have not been altered by international convention, then in our submission they ought to be applied. Now, I want at this point to deal with the final question, which I can do very briefly. If, contrary to the submission that I have been making this morning, there is a common law rule of non-justiciability, then it will be necessary for this court to consider whether that common law rule can survive the enactment into English law.
Just before we go there, has it underlaid all your submissions that the principles that will be applied in the United States are essentially international principles that are applied in this country?
Yes. In the relevant, that wouldn't be true of all disputes.
No.
But the actual substantive law, the submissions I was making yesterday about the extent of the rights, are very similar in the United States as they are here. The list of protected items is much the same. The distinction between functional and artistic is much the same. And the judgments given in the US courts are rational progressions from those premises.
How about measure of damage?
I don't know what the rule about measure of damages would be in the United States, and I can't therefore compare it with the English rule.
Would it be applied, the United States rule, if there were a significant difference?
Not necessarily, because the measure of damages, but once you have ascertained the extent of the obligation, is frequently regarded as a matter for the lex fori.
The treble damages would be knocked out, for a start.
Treble damages would certainly be knocked out, yes.
And then you've got here absolutely vast damages awarded for relatively small infringement.
Well, I don't know how small it was, but I agree as a matter of instinct one suspects it was less than 20 million. Problem is that was a default judgment.
The 20 million includes the trebling.
I'm sorry,
The 20 million includes the trebling.
yes, it does.
Yes.
Could I ask you, infringement of intellectual property rights is sometimes regarded as a sort of statutory tort.
Yes.
But I don't think there's any hint in any of the cases you've shown us of anything about double actionability. That simply doesn't arise at all.
It might have arisen before the double actionability rule applied, and in before it went. Forgive me, and in the Over Arup case, and also in Mr. Justice Brown Wilkinson's decision in Def Lep, there is some consideration of the impact that the double actionability rule had on this in preventing English courts from not as a matter of jurisdiction, but from giving effect to some foreign intellectual property rights on the footing that the territorial ambit of each nation's protection meant that the breach of an American intellectual property right in America would not be actionable as such in England. The only thing that would be actionable in England was a breach of the equivalent right in England. And it's been suggested that that would mean that the double actionability rule would effectively have prevented you from succeeding, as opposed to establishing jurisdiction, in an action on a foreign intellectual property right. Now, we no longer have to decide whether that would in fact have been a rational course for the law to take, because the double actionability rule is gone.
It's quite a good discussion of that by Mr. Prescott, isn't it?
There is indeed, yes. Now, the last point on this appeal, it concerns the question whether, if there is a common law rule of non-justiciability applied to copyright issues in this action, it can survive the judgments regulation, even as between the United Kingdom and a country such as the United States, which is not party to it. Now, this depends on the decision of the European Court of Justice in Owusu and Jackson, which the court will find in bundle 3 at flag 12. Yours or mine? Now, Owusu and Jackson has, of course, been very strongly criticised, and I can say straight away that I quite accept that there is a great deal of force in some of those criticisms. But it's the law, and nobody can say that it isn't clear. What the European Court of Justice held was that an action in England against a domiciled Englishman and a Jamaican company for negligently allowing the plaintiff to be injured at a holiday resort in Jamaica couldn't be stayed on grounds of forum non conveniens. It couldn't be stayed in favour of the Jamaican courts. And the reason given for that was that the English defendant was domiciled in a contracting state. Therefore, the default rule of Article 2 of what was then the Brussels Convention applied, and it was held that the assignment of jurisdiction to the state of domicile applied not only where the alternative fora were the fora of two contracting states, but also where the alternative fora were the fora of the United Kingdom and a non-contracting state. Now, that was held to be so, notwithstanding that the Brussels Convention imposes, of course, no obligations on non-contracting states. Now, in Owusu, one can get the head note, so to speak, from the declaration at the end, flag 12, in the bit in bold type. The Convention, and then one can go to halfway down the bit in bold type, precludes a court of a contracting state from declining the jurisdiction conferred on it by Article 2 of that Convention on the grounds that a court of a non-contracting state would be a more appropriate forum for the trial of the action, even if the jurisdiction of no other contracting state is in issue, or the proceedings have no connecting factors to any other contracting state. Now, the essence of the reasoning will be found between paragraphs 37 and 46 of the ECJ's judgment. And in particular, at paragraph 37, it must be observed first that Article 2 of the Convention is mandatory in nature, and that according to its terms there can be no derogation from the principle that it lays down, except in the cases expressly provided for by the Convention. It's common ground that it's common ground that no exception on the basis of forum non conveniens was provided for by the authors of the Convention, although the question was discussed when the Convention on the accession of Denmark, Ireland and the United Kingdom was drawn up. Respect for the principle of legal certainty, which is one of the objectives of the Convention, would not be fully guaranteed if the court having jurisdiction under the Convention had to be allowed to apply the forum non conveniens doctrine. And paragraph 40, the court has thus held that the principle of legal certainty requires in particular that the jurisdictional rules which derogate from the general rule laid down in Article 2 should be interpreted in such a way as to enable a normally well-informed defendant to foresee which courts, other than those of the defendant in which he is domiciled, may be sued. Now, that I think expresses the essential reasoning of the decision. It boils down to 2 points. First of all, Article 2 is mandatory, and therefore there can be no derogation from Article 2 unless it is provided for in terms elsewhere in the Convention.
It's completely illogical on that point, isn't it? Because there's absolutely nothing to stop you if you can find him abroad, if he happens to be have a sufficient connection with the United States, suing him there.
Yeah.
So, I mean, this turns defendant's protection into plaintiff's protection.
Yes, well, possibly, yes. I mean, I am not going to submit to this court that if the matter was free of authority, this would be a sensible decision for you to reach. It isn't.
But would this give jurisdiction in relation to dispute about title to land in Jamaica?
Well, subject to Article 16.1. Because Article 16.1 deals with those...
22.1.
16.1 of the Brussels Convention, 22.1 of the regulation. If it's not within the exclusive jurisdiction of 22.1, for example, if it was a personal obligation, then you would revert to the default rule, which is Article 2. That positively confers jurisdiction on the court of domicile, irrespective of the location of the land. If, as the ECJ has held, Article 2 is mandatory and only an express derogation elsewhere in the Convention will enable you to depart from it, then Article 2 would have to be applied unless it was an exclusive jurisdiction case.
Isn't the difficulty about exclusive jurisdiction that the Article 22 only applies to land within the EU?
Yes.
So that there is absolutely no regulation, if you take a wuzu, which governs the position of land in New York.
Yes, though, one can conceive of cases where forum non conveniens might dictate that you argue about French or British land in New York, for example.
This leads to this whole discussion of reflexive effect, and whether you can apply these provisions by analogy.
Well, yes, it does, and that's a point which we have raised in our printed case. Where's my... Sorry, I've got to find my copy of it. Oh, here we are. No. My slim copy of the printed case. This is dealt with at paragraph, on page 37 of our printed case, paragraph 56, subparagraph 1. This is the unresolved question, whether you can apply, e.g. Article 22 or Article 16 of Brussels by analogy, where the appropriate jurisdiction is that of a non-member state. And that is actually a point that was considered by the Advocate General in Owusu. And indeed, the second of the questions referred to the European Court in Owusu would have required it to decide that, but it declines to do so.
But if there's no reflexive effect, it leads to absolutely absurd.
It leads to difficult conclusions, even if there is a reflexive effect.
If we get here, this must go to Luxembourg, mustn't it?
If that's the only point left, yes. If the reflexive effect is what it turns on, then because that was not decided in Owusu, the court should not send to Luxembourg the first question, which was decided, has been decided. But if the second question becomes the keystone of the arch, yes.
The combined effect of Owusu and Turner and Grovit probably is, isn't it, that you can't avoid the application of these rules by dressing up the the refusal to take jurisdiction by such notions of abuse of process or act of state or anything like that. If it looks like jurisdiction, then it's got to be. Yes,
because the Convention is concerned with both what we would call subject matter jurisdiction and personal jurisdiction. The subject matters that are dealt with specially are dealt with in paragraph 22, article 22. If you're not within those, then you're compulsorily sent back to the provisions dealing with the personal jurisdiction. But it is a scheme which encompasses both, so your Lordship's absolutely right.
I think it might be worth looking at the Lugano opinion. Right at the end, there's a paragraph which, although you have to interpret it with a cold towel around your head, I think suggests that there is no reflex effect. I mean, it doesn't solve the problem in a way which would avoid a reference, but it's just a matter of interest. I think the European Court has taken a hard line on that.
Yes, I will have a look at that.
It's somewhere near the very end of the long Lugano.
I'm conscious of the bit that your Lordship is talking about. But, now, the Court of Appeal's reasons for declining to follow Owusu are, in our respectful submission, really very strange. The relevant parts of the judgment of the Court of Appeal are between paragraphs 103 and 134. Now, I'm not going to read out great chunks of that. The Court will no doubt recall the main lines of it. But essentially, the Court of Appeal could not believe that the European Court had created, as they put it, by a side wind, a national jurisdiction over a subject matter that had nothing to do with the EU except that the defendant was domiciled there. Yet that was the very issue which had been referred to the court in Owusu, and the very issue which was dealt with in terms in their declaration. And the judgment of the Court of Appeal argues strenuously against the ECJ's conclusion, as if, instead of being a statement of the law by the determinative court on these matters, it was a mere argument of counsel to be rejected if it was found to be unsatisfactory. Indeed, much of Lord Justice Jacob's judgment does read like the argument of the unsuccessful counsel in Owusu itself. His misgivings about the decision are fair enough as far as they go, but they simply can't justify ignoring it. And what certainly cannot be said in our submission is that the decision was arrived at without consideration of the arguments against it. We have included in flag 15 of volume 3, I won't turn it up now, the opinion of Advocate General Leger, which was accepted by the court. And we have analysed that opinion in our printed case at paragraph 56, with a view to pointing out that every one of the objections, with one exception only, raised by Lord Justice Jacob to the conclusion reached, was in fact anticipated and considered by the Advocate General, and must therefore have been in the mind of the court when the matter was decided. The only objection that wasn't anticipated and considered by the Advocate General was the objection which is considered by Lord Justice Jacob at paragraphs 109 to 111 of his judgment. And that was the objection that the Convention, and now the EU Judgments Regulation, doesn't provide for the recognition of judgments in the courts, given in the courts of non-EU countries. Although, as Lord Justice Jacob points out, the general scheme of the Convention is that the assignment of jurisdiction to particular states is generally carefully balanced by an obligation of other states to recognise the judgments which are given by those states. Now, that of course is all true, but it does with respect miss the point. The Convention doesn't deal with the recognition and enforcement of non-EU judgments because it doesn't assign jurisdiction to any non-EU courts. On the contrary, Article 2, as construed by the Court, expressly excludes the jurisdiction of a non-EU state because it applies only to confer jurisdiction on a state of which an EU national is domiciled. Now, that policy, as applied by the ECJ, may be thought chauvinistic, if you can be chauvinistic on a European scale. I think you quite clearly can. But it was clearly a deliberate policy. The ECJ construed the Convention as being concerned, they said this in the passage I quoted, with the protection of EU nationals by allowing them to be sued at home. Now, it can perfectly be fairly said by Mr. Ainsworth that isn't much comfort to persons like him who would rather not be sued anywhere at all, even if it is established that they have committed the relevant wrong. But there is, I would suggest, no obvious reason why the draftsman of the Convention or the regulation should have had any sympathy with that position, nor, in my submission, should this Court have any sympathy with it. Now, I've taken that last point very quickly because I need to give my learned friend enough time to develop his own submissions. But unless the Court has any other matters that they wish me to deal with, those are the submissions I make in support of the appeal.
Does Owusu mean that if you sued a defendant who was domiciled in the EU, if you sued him to judgment in the United States, that judgment would be contrary to public policy or
No.
EU law to recognise it here?
No, it wouldn't be recognised by the positive provision of EU law.
No, but you could still recognise it.
But you would still be able to enforce it under ordinary principles of English, in our case, private international law.
Thank you. Mr. Block. We'll adjourn until 2:00.